Okay. Hi, I'm Brian Carver, one of the co-founders of Free Law Project with Mike Listener. I'm going to talk about the history of Free Law Project, but I say this is according to Brian Carver because while I am going to talk about the history of Free Law Project, it may take me 15 or 20 minutes before I really get into those details. The reason for that is I want to explain to you how I see Free Law Project as part of a larger effort to provide the public with access to the law. To give you that broader context, we have to look at some related history and ask some questions about why one would pursue these sorts of efforts at all. But to begin, if one had never heard of Free Law Project and wondered what it was, you could look at this document we had to file in 2013 and to become a nonprofit, Free Law Project's Articles of Incorporation, which describe its charitable purposes. It says the specific purposes of Free Law Project are primarily to provide free, public, and permanent access to primary legal materials to the internet, on the internet, to develop, implement, and provide public access to technologies useful for legal research, to create an open ecosystem for legal research and materials, to support academic research on related technologies, corpora, and legal systems, and to carry on other charitable activities. So to start off, I want to focus on that first purpose, providing free, public, and permanent access to primary legal materials on the internet. And to define a phrase, primary legal materials, that's meant to include not only the literal laws, as in statutes, but also the judicial opinions that interpret those laws, as well as other materials that are essential to the judicial process. They are primary as opposed to secondary legal materials. That might be something like a copyright treatise, written by an expert, like by my friend Bill Patry. But so throughout, when I talk about access to the law, I'm always going to mean all these primary legal materials. And then what follows in particular, I want to explore why would one want to provide public access to the law? Whether that public access should be free, permanent, and on the internet, we may have to save for another time. But it turns out public access to the law is an old idea. Consider Free Law Project Babylon. So the Code of Hammurabi is not the earliest surviving law code. There were supposed to be more laughs there, by the way. But what I'd like to highlight here is the public's access to these laws. It's written in the common language of the people, and while literacy in ancient Babylon may not have been as high as one would like, this is an effort towards public access. Second, it's put in a public place where anyone can see it. This is public access to the law. And since the punishments described by many of these laws is execution, it seems really important that the public know the laws. But the code itself explains part of the motivation. The epilogue of the code says in part, so that the mighty might not exploit the weak, and so that the orphan and the widow may be treated properly. I have written these very special words of mine on this stone. I have set them together with the image of me, the king of justice in Babylon, so that disputes may be settled in the land, so that decisions may be made in the land, so that the oppressed may be treated properly. It goes on a few paragraphs later, let any man oppressed, anyone who has a complaint, come before this statue of the king of justice, and let him have the message on the stone read aloud, and let him listen to the treasured words I have written, and may my stela resolve his complaint, and may he understand his problem, and may he be content in his heart. So public access to the laws is about preventing the mighty from exploiting the weak. It's so the orphan and the widow may be treated properly. It's also about resolving complaints and being content in your heart, right? That sounds really important to me. But the Code of Hammurabi is just one of many ancient examples of providing public access to the law. In Sumer, the law was written down. Look at that third bullet point describing Free Law Project Mount Sinai, which famously included laws on 2 stone tablets. But note, Free Law Project supporter Moses reportedly got angry over some golden calf worship, and he smashed that first set of tablets, requiring replacements. This is one reason Free Law Project has made a lot of backup copies of the law throughout its existence. But we have examples of public access to the law in ancient Athens. Pictured in the background of this slide is the law inscribed on the wall in Crete. Bronze tablets containing the law were displayed in the Forum in Rome. The edicts of Ashoka were carved into cliff faces along trade routes in what is today India, Pakistan, and Afghanistan. But you might object. Just because people have been providing public access to the law since ancient times doesn't really explain why they were doing that, or that it's necessarily even a good idea. So let's focus more precisely on that why question. Let's ask ourselves, what sort of system do we prefer? One where might makes right, and those with power are above the law? A system where whatever the leader says, that is the law? Or another flavor of that, not based purely on might, would be one of divine ordination, where one believes that a deity has ordained the leader or leaders with absolute authority, and so whatever they say is the law. But in these and other similar systems, the key feature we're identifying is that there is some leader, or often including the leader's close associates, who are above the law and can do whatever they like without fear of legal retribution. Alternatively, we can think about systems where the rule of law prevails. On this approach, no one is above the law. Whatever the law says governs everyone. The very power of any government that is put in place derives its authority from the people themselves, who are seen as the ultimate authority. We can look back to the origins of democracy in ancient Greece, or the Magna Carta that rejected the divine right of kings, the Declaration of Independence in the United States, and since we have here today an audience from a wide range of countries, I've listed some constitutions and the UN's Universal Declaration of Human Rights that each establish these same ideas that favor the rule of law. The law's application being applied equally to all people, and the ultimate source of governmental authority arising from the people. So on one side we have authoritarianism, dictatorships, tyranny, and on the other side we have the rule of law, which has been preferred and chosen by just about every people of every nation given such a choice. So I wanted to tell you here about the Judicial Integrity Group, made up of heads of the judiciary or senior judges in their respective countries, their adoption of the Bangalore Principles in 2001, similar groups at the United Nations or the American Bar Association, but it's really an entirely separate presentation. So I have to sort of skip over some of that and just sum it up by saying, when you get together experts on the rule of law and the judiciary, and you have them put together a report like some of the ones cited here, they will draw a straight line from the rule of law to judicial transparency. If you want rule of law and not just a corrupt system full of bribes, then you've got to have judicial transparency. And what does that amount to? Well, here's from one of my favorite documents. Judicial proceedings need to be conducted in public. The judiciary should ensure that the public has reliable access to all information pertaining to judicial proceedings. Such information should include reasoned judgments, pleadings, motions, and evidence. If we turn to this document from an office of the United Nations, I don't know of 152 pages better on the judiciary than this. Just a few brief excerpts. It's equally important to provide the public with ready access to court documents, especially judgments and other decisions. I'm going to give you these slides so you can read all this stuff on your own. But it goes on and says, publication of judgments allows the public to scrutinize the actions of judges. Publication also regularizes the application of the law and makes judicial decisions more predictable and consistent, thus improving the quality of justice. So there's two different things being identified there. One is public scrutiny lets you root out the corruption, but also within the judiciary itself, you want them to apply the law consistently and in a regular fashion. Goes on, publication and distribution is crucial in ensuring that lower court judges are following the law. Pleadings, motions, court schedules, court files should all be accessible. Okay, so when you've been arguing for public access to the law and saying that this has to include not just the final judgments, but everything on the docket for over 16 years, like Mike and I have, you can sometimes start to ask yourself, what's taking so long? Am I crazy? Is it me? Do I have an unreasonable ask here? But no, as I mentioned, in these sorts of reports, they're prepared by large teams of international experts, and you find them saying exactly what we've been arguing for and trying to accomplish all this time. But Mike and I and the rest of Free Law Project are standing on the shoulders of giants. So to better put Free Law Project's work into that broader context, let's look at some of the other efforts at public access to the law. While these are extensive, I'm inevitably going to, omit some very deserving folks, so apologies in advance. My time is limited. I'm going to have to hustle through this. Let's think about Cali. It hosts and facilitates Cali Lessons, which is a library of legal tutorials written by law professors geared towards law students. In 2012, they started publishing open case books, their E. Langdale Press Publishing wing. They've partnered with the Chicago-Kent College of Law and their Center for Access to Justice and Technology to create A to J Author. We have an expert on that here. That's a tool designed to create guided interviews that help self-represented litigants to navigate the legal landscape. Cali hosts an annual conference for law school computing. John Mayer's been the executive director since 1994. What a legend. Jerry Goldman says he was watching the Chicago Cubs at Wrigley Field when he first got the idea for creating a multimedia Supreme Court experience. This is in the late 80s. Right? The legal world is grateful that those baseball games were not more engaging because his earliest version, which was based on HyperCard stacks, any old Apple users, has evolved into the absolute best way to experience oral argument recordings from the Supreme Court of the United States. OYE is still operating, so that sort of longevity is what we'd like to emulate at Free Law Project. Jerry gave Mike and I an enormous amount of helpful advice in the earliest days of Free Law Project. Love that guy. In the 90s, Matthew Bender, a longtime legal publisher, went to court seeking a declaration that Bender's insertion of star pagination into West case reporters in its CD-ROM version back in that time of judicial opinions shouldn't infringe West's copyright. That is, you can't copyright stars, right, was the idea. And Hyperlaw, this was run by Alan Sugarman here, he intervenes in the case and says, yeah, I want that same relief because I'm doing the same stuff, right? And he's a real access to case law hero. He's been at it since the early 90s, founding Hyperlaw in 91. Matthew Bender eventually gets acquired by Lexis, but Sugarman does end up winning his case against West, has to go all the way to the Second Circuit to do that. And that's to everyone in public access to the law's benefit. He continues to advocate for things like neutral citations, has been doing so long before a lot of people cared about that. So, amazing guy. Cornell, their Legal Information Institute was founded by Peter Martin and Tom Bruce in 1992. Even in this early version of the site that I'm showing you here from 1996, the main menu lists legal material organized by topic, legal material organized by type and source, and judicial opinions gets listed there in parentheses. So they've been at this a very long time. They continue to this day. Their versions of the US Code and the Code of Federal Regulations are so good, we at Free Law Project have never bothered to work on those ourselves. Peter and Tom have also been incredibly generous with their time over the years, helping Mike and me and the Free Law Project in so many ways. It continues on under the leadership of Sarah Frug. FindLaw, they have a timeline on their site that says in their earliest entry, 2 attorneys compile a list of internet resources for a group of California law librarians, then decide to post the information on the internet. The rest is history. And most of those histories would also include Martin Roshheisen as a co-founder. And while FindLaw still exists, I list it as ending in 2001, as that's when it was acquired by Thomson West, now Thomson Reuters, the owner of Westlaw. But this is not the last you will see of these two faces, so stay tuned. As we pull up to 1997, can you believe we haven't even hit 2000 yet? We find that the first Law via the Internet conference happened in 97, a conference that continues to the present, with a lot of thanks due to Ostley and Graham Greenleaf, especially in the early days. This is the conference of the Free Access to Law movement. It's an international voluntary association which has as its members more than 60 organizations from around the world. Free Law Project is a member. And I should mention, you should go check out their website and look at all the different legal information institutes that are members of FALM, because it's actually one of the main reasons that we haven't gone beyond U.S. Case law and other judicial materials so far, because in many cases, there's already some legal information institute working on those other geographies. There's several LIIs in Africa. I mentioned the Australian one has been around forever. And there's 60 of these groups. And so in large part, there are other folks handling that, and we haven't quite solved our own problems yet. But there's more countries than 60 in the world, so there's still room, right, for world domination, which I'm also in favor of. But FALM members provide support to, they support free access to legal information. Consistent with these principles, there was a declaration on free access to the law, which was adopted in 2002, and that reads as you see on the screen there. I won't read that to you. And it goes on for much further than that. Go check it out sometime. Let's give government a tiny bit of credit in this parade of access to the law. The E-Government Act of 2002 has a Section 205 that required federal courts to maintain websites that contain access to docket information, access to the substance of all written opinions issued by the court, and crucially, it mandated that these written opinions be available in a text searchable format and free of charge. That provision is one that we frequently cite, and those in the free access to law movement, when you're challenging paywalls for legal documents. So it's one of the reasons that we can get access to this federal stuff at all. Hey, we recognize these folks. So in 2003, Tim and Stacy come back and they found Justia. It's a major online platform providing free access to legal information. They've got case law, codes, regulation. They've been longtime supporters of Free Law Project, often kicking in funds when we needed it. They also spread that support around. You'll see their names associated with many of the other efforts I'm mentioning. They're donating either documents or financial support. Super nice folks. Okay, so I list Carl at this point in my timeline as he founded public.resource.org in 2007, but Carl was putting government documents on the internet probably before any of us in this room were even on the internet. If I did a separate 45-minute talk on all of Carl's contributions in this space, I'd just be getting started, right? He made SAC filings public. He collected C-SPAN recordings, put state-mandated safety codes online. Almost everyone got their copies of Supreme Court cases from Carl. His initial collection of case law also included a bunch of documents from Ed Walters at Fastcase, another great guy. But this court opinion, the citation that you see here, Georgia versus publicresource.org, it represents his Supreme Court victory that held that annotations within the official code of Georgia annotated are not copyrightable because they're created by legislators in their official capacity. This decision confirms the government edicts doctrine and that it applies both to judges and legislators placing works that are produced by a legislator or a judge in their official capacity in the public domain. That's crucial for us. Featured in the middle of this slide was his PACER document recycling effort, where you could upload your PACER documents. As with many things in the public access to law space, it's an example of Carl doing something first, and we're going to see how others, including Free Law Project, tackled the PACER problem subsequently. But Carl continues his work in these spaces with more technical standards litigation ongoing, great efforts in India. He's got a YouTube channel where you can watch public domain US government films such as Duck and Cover, right? There's truly too much to cover it all. The Administrative Office of the Courts deserves some credit for having this idea in October of 2007. They were going to open up PACER access by making some free terminals available at 17 libraries. But they shut the program down when they noticed that Aaron Swartz had taken them up on their offer of free access by writing a script to download over 19 million documents. If you don't know the details of Aaron's story, there's a 2014 documentary film called The Internet's Own Boy, the story of Aaron Swartz, that I'd highly recommend. In 2007, two law professors announced that they and their respective law students were partnering to make court opinions searchable. We had bulk availability in many places, but a really great search interface on them was not really a thing in 2007. They too got their documents from Carl at publicresource.org, and they were trying to put that decent search front end on there. Stephen Schultz was at Princeton's Center for Information Technology Policy, and at that time was not a lawyer, but he had the misfortune to encounter the PACER system, and he thought it was nuts, because it is nuts. And in particular that you have to pay now 10 cents per page for digital documents. It just harkens back to a time of photocopiers, right? Well, so with some graduate students there at Princeton, they built a browser plugin, Recap, that enabled a crowdsourced solution to the problem. You install the plugin, and when you pay for Pacer documents, the plugin uploads those public documents to a central repository. And just in case you've never seen what this looks like, the plugin adds little recap icons to your Pacer experience so that you can see what documents are available from the Recap repository. And you can choose to retrieve those from Recap directly, saving you money off your Pacer bill. This is a truly genius bit of software with a clever name to go with it, right? Note what Recap spells backwards in the tagline, Recap, turning Pacer around. Okay. Well, in November of 2009, Google Scholar added case law. That's an incredibly useful thing, but I have never felt like it solved the public access to law problem because one, their coverage fact does not give us any promises about what courts are covered each day or how timely those updates will be. No detailed statistics on coverage provided. And two, because there's no guarantee it will be there tomorrow, or that if Google did choose to shut it down, that the public would be able to take that collection of documents and carry on the work elsewhere. This goes to one aspect of FLP's first primary purpose, free, public, and permanent access. This is free and public, at least to US users, but we have no guarantee that it's permanent. But Brian, why would you be so worried that a giant collection of case law might one day just disappear? Remember alt law? As soon as Google got into the game, they decided, oh, okay, well, we're going to shut down because now Google solved the problem that we were trying to address of putting search on top of case law. But anybody who wanted to collect as much case law as possible and make it searchable now has to start all over again. Their site just disappeared. The documents, where are they? I don't know. If you could get in touch with these guys, maybe they would give them to you. But that's not how this should work, right? They did all this hard work to make it free and publicly accessible, and then it's gone. It vanishes. Okay, finally, from this point forward, with just one brief exception, what remains is going to be solely about Free Law Project and not what everyone else in this space has done. In the fall of 2009, I was on the faculty of the School of Information at UC Berkeley, which is housed in the beautiful South Hall, the oldest building on the Berkeley campus. Mike was in the master's program there and had taken a couple of law classes from me. All master's students at the high school, as we call it, have to do a master's final project. So many students will come to a professor's office hours in the fall of their second year to discuss possible project ideas. Mike and I were having such a discussion when I proposed, hey, why not solve a problem that I have? I like to know anytime a new copyright decision comes out from the Federal Circuit Courts of Appeal. I had used various paid daily awareness services, but they were always either over-inclusive and would provide information about every single new case from the Ninth Circuit or whatever, when I only care about certain ones, or they would be under-inclusive and they would only provide information about the new decisions that they could find somebody to write a summary of, or that they thought were important, which doesn't address my unique interests, which are weird. Right? And so none of them were timely enough either. You might get these things at the end of the week, or maybe even the end of the month. And I want to know, within 30 minutes of an opinion hitting a court website, that it's out there and that I might be interested in it. Because at least back in this time, blogging was still in style. And I wanted to be the person writing a blog post about a new case rather than learning about that new case from somebody else's blog post, right? The 13 circuit courts and the Supreme Court, we're all posting their opinions on their websites. So I say to Mike, why don't you build a scraper to collect all those, put them in a database, make it searchable for my queries, then make it send me an email every day with the opinions that match my queries. Google Alerts existed at this time. And so basically I wanted Google Alerts for the courts. And Mike listened to all this and he was like, yeah, I could build that. And so a couple months later, the first version of Court Listener, March 2010, which did provide those daily alerts for me. In a matter of months, Mike had built a free tool that anyone could sign up and use that was far better than any of the paid services I had ever used. It's super cool. And it's not all exactly shown here, but there's at least 3 distinct things that come together to make this work, right? There's Juriscraper that crawls the court websites and collects the opinions and the metadata about them. There's a back-end database that stores the opinions, the metadata, and the user account info. And then there's this front-end website that allows users to interact with the database, set up alerts, search queries that interest them, right? So Mike graduates, he gets a job with a legal search company. They let him work 4 days a week, and he continued to work on Court Listener on Fridays and in spare moments here and there. I think in this time period, I have more emails back and forth with Mike than with any other person on the planet. I probably talk to him every day. Some days I talk to him more than I talk to my own family, right? Like it was still a period of intense work, and he had left the program. But I would also like to note that even from these earliest days, we were thinking about continuity. Mike licensed all the code under an open source license. All the documents we collected have always been downloadable in bulk. And the purpose behind those two facts has always been to make the project unstoppable, right? I say this a little too much in presentations, but even if Mike and I were both hit by a bus, we wanted someone to be able to download all the documents, download all the code, set it up on a new server, the next day, keep on going, right? There was not going to be any disappearing website that just suddenly everybody lost access to all that hard work. Well, I continued at the iSchool, and in May 2012, managed to rope 2 other students into working on this project, and they built the first version of Court Listener's Citator. Now, you may know that a citator creates the citation network between legal decisions, showing which opinions cite each other. This enables something like a table of authorities when you're browsing a particular opinion. And a table of authorities can be created the day an opinion comes out, because that lists every opinion that is cited by that new opinion. It's backwards looking. The subsequent treatment develops over time, right? As time passes and more new opinions cite back to a given opinion, those opinions become part of its subsequent treatment and tell us about whether that decision is being followed, distinguished, or even overruled by subsequent decisions. Working on this sort of thing also teaches you what a mess legal citations are. We'll return to that theme as we go on. By August and September of 2013, Mike and I had been continuing to talk about how to improve the site, cover more jurisdictions, collect more case law, various features, until he decided he'd like to make this his full-time job. So to do that, we needed to form the nonprofit to employ him. However, I'd also like to note that the nonprofit couldn't actually afford to pay him for quite some time, and has never paid him as much as he's worth. So it was quite a leap of faith for him to try this. And here again are those primary purposes of the nonprofit from the Articles of Incorporation. Shortly after forming the nonprofit, we announced the first ever API for the law. This meant that others could more easily take advantage of the work we were doing. Developers of other websites can connect what they were doing to what we were doing, so people could do things like include a list of relevant opinions on your website, get a list of the new opinions of the day, and all these other things. And I continually remain shocked that the powers that be allowed us to become the legal infrastructure of the internet. Like, it's kind of a really dumb move, right? But we were first and claimed that territory, and we'll see later when we look at some statistics whether maybe now we own it. So we've already mentioned the recap plugin, but this project started at Princeton, and by this time in May 2014, everybody who had worked on recap had left Princeton. And we at Free Law Project have been trying to keep it running for months, but to really keep it going for the long term, we needed to totally rebuild it, bring it into our infrastructure, and luckily the folks at Princeton were smart enough to have us take it over rather than just let a fantastic project die. It was also hugely complementary to our existing case law collections. As to that point, we had really focused on the federal circuit courts, the Supreme Court, and the state appellate courts, without doing a lot of collection at the federal district court level. But that's precisely what recap largely contained, federal district court material. So merging those two collections, it just seemed meant to be, right? Okay, so now to actually finish this talk in a reasonable amount of time, we have to just give a brief overview of an 8-year period. Starting with JurisScraper, our scraper that collects new opinions from court websites, finally covering all the state courts of last resort. That's usually, but not always, called their Supreme Court. I'm looking at you, New York. Some state court websites remain to this day very difficult to deal with. So getting to this point was a great milestone. But we still needed to fill in many mid-level state appellate courts. We began collecting oral argument audio, adding an entirely new media type. Some courts were actually rotating old audio off of their websites to save on storage space. And it always made me so concerned that the public might be losing access to some of this material forever if we didn't start saving copies. So we did. I mentioned how difficult legal citations are, so the release of reporters.db is a giant gift to the world of people that come behind us and also try to sort out that complex history of legal citations. Until January of 2015, our alerts had at best been daily, but we finally launched real-time alerts, and that was something I had wanted since the very beginning. But then there's one item here that is not a Free Law Project specific highlight. It's that October 2015 announcement of the Harvard Law Library's Case Law Access Project. They announced that in partnership with the legal startup Revell, they're going to scan all their case law books. There were some clever access provisions built into the deal that tried to give Revell value for their money, but that also provided for gradual public access and eventually a total public release. I've also written something a long time ago now, but have not published it yet, on just what, quote, the entirety of U.S. case law could even mean, right? If this is what we're trying to collect, the entirety of U.S. case law, how would we define it? Well, spoiler alert for my unpublished piece, the conclusion is basically that whatever reasonable definition you might pick, we generally presume that the Harvard Law Library has it, right? They have everything. So if the Harvard Law Library is going to scan and make available everything they have, then the public is going to finally have the ability to get public access to the entirety of U.S. case law. Okay, more on this later in the timeline. We started a judicial database, added campaign finance information. In November of 2016, finally you got searchable, Pacer, and Recap. It's kind of hard to even imagine what a big deal that is because we've had it now for 10 years nearly. But how could Pacer lack this functionality, right? Like you can search for a case name in Pacer, but you can't search for a keyword like asylum, right? We made that possible on our collection of Pacer documents, opening it up to all kinds of new research. By August of 2017, we've got every free opinion on Pacer, Pacer docket alerts, even an API. iCite makes it possible to find legal citations in any block of text, and we spun that tool out on its own. The Harvard Case Law Access Project helped us with it and used it themselves. Now that pain that Rowan and Karen felt all those years ago on the first citator, and that Mike had felt for years, and many of you, I'm sure, it's maybe not eliminated, as legal citations can still find ways to frustrate you, but iCite dramatically reduces the pain, right? The combination of Reporters DB and iCite makes it so you can just find citations in any block of text. Problem solved, hooray. We publish a database of judicial financial disclosures. Journalists at the Wall Street Journal dive into it, publish a bombshell article. More on that in just a second. Yeah, because I need to mention, I thought I was going to do highlights, and now I'm talking about every single one. But partnering with the Tennessee Workers' Compensation Courts, that makes us their reporter, right? We're the official version of their reports. That's a very cool thing, and we need to do a whole lot more of it. We get the recap email addresses. But what about that Wall Street Journal article? So they published this in September of 2021, and they find that 131 federal judges had broke the law by hearing cases when they had a financial interest. They failed to disqualify themselves from 685 court cases around the nation over that 10-year period or so that they looked at. About 2/3 of their rulings on motions that were contested came down in favor of their or their family's financial interests. That seems suspicious, right? And so the journalists at the Wall Street Journal used our judicial financial disclosures database to do this research. It's a great article that you should go read. I wanted to read a bunch of quotations from it because the judges' reactions are galling. If you go into court with some of the same kind of explanations these judges gave, it would not fly. But that work led directly to the 2022 Courthouse Ethics and Transparency Act, CETA, that fundamentally changed federal law by requiring judicial financial disclosure reports to be published in a searchable online database within 90 days of filing. FLP is still collecting these financial disclosures for our database. In March of 23, we launched bots.law as we took over the big cases bot that Brad Heath of USA Today had set up to track big cases of general interest to journalists and the public. He left USA Today, wasn't maintaining it anymore, and we convinced them to give it to us and let us get it back into shape again. It had over 53,000 followers at the time, so we were excited to be reaching a lot of people with those tweets. Now there's also specialty little cases bots. They initially all worked on Twitter, Mastodon, and Blue Sky, although now, with Twitter's transformation into X, we're focusing on Mastodon and Blue Sky. There's a tech cases bot maintained by The Verge, there's an antitrust cases bot, a trademark cases bot, a free speech cases bot, and of course an AI cases bot. You can volunteer to curate one about your special area of interest. So then, in March of 2024, we finally reached the end of that Harvard Case Law Access Project. And they had a big conference. They invited Mike and I. We went up there and got to hear a panel discussion about all this. And the results are impressive, right? They end up scanning 6.9 million unique cases across 612 reporters. That's over 36 million pages scanned. What I think is maybe more impressive is that courtlistener.com has every opinion that the Harvard Law Library scanned and more. Let's think about that for a second. Let's look, we're jumping out of the timeline a little bit to look at current numbers. We've got over 8.2 million precedential opinions in Court Listener, state and federal. Over 2,300 days of oral argument audio that would take you more than 6 years to listen to if you didn't speed it up. Around 12,275 alert emails are sent daily. That's a over 50% increase in just the last 2 years. We get nearly 1 million API calls every day. That's an over 500% increase in the last 2 years. In recap, we've added 100 million docket entries in the last 2 years. Like, when you do this search in the empty search in recap, it comes back about the cases that we at least have some metadata about. That's 60 million cases and 460 million docket entries. But there's a little option you can check, say, oh, just show me the ones where we actually have a PDF, we have some document. There today, we have 4.2 million cases and 16 million docket entries. That's 16 million PDFs. So even if every one of those documents was just one page, at 10 cents per page, that'd be over $1.6 million. But we actually know from a survey of 2 million PACER documents done back in 2016 that the average length of a PACER document is actually closer to 9.1 pages. So ignoring the fact that opinions in PACER are supposed to be free, and they so often are not, this is a collection of documents that would cost you over $14.5 million to put together if you had to do it all over again from scratch. And that's not even counting the 8.2 million opinions we have in Court Listener proper. Wow. Right? So I don't think it's an exaggeration to say that in about 15 years, we put together a collection of data worth over $20 million, right? And we give it all away for free every single day. We've got, in April 2024, back to the timeline, sorry, a study that we did on court e-filing and case management, did interviews and 10 hours of conversation, found these themes. Turns out e-filing systems and case management systems are bad, and they really don't work for self-represented litigants. Go read that report if you haven't. Then in March of 2025, AI comes to Court Listener. We get semantic search, right? This gives you domain-specific understanding, right? Our fine-tuned model correctly identifies the semantic relationships between legal queries and documents, understanding specialized terminology and concepts that general models often miss. We released Inception, open source high-performance microservice to seamlessly generate embeddings for legal documents and queries. We published our own domain-adapted semantic search model that specifically understands legal terminology and concepts. So much happened in 2025, I had to also condense it, right? We did a case law page redesign in March. We got recap search alerts in June. oral argument transcripts in July. Remember how much oral argument audio there was? That's a lot of transcripts. We got the Lib Guide in September, which is a guide for using all of our tools for librarians and law students and those who want to figure out how to use the tools. I meant to look this up. We also started creating some YouTube videos that explain this stuff. I don't remember where that falls on the timeline, but I love the YouTube videos. Go check those out. And then we announced the Justice Partner Circle, where people can support our work in a new way. In October, Mike received the Foundation for Improvement of Justice Paul H. Chapman Award. There's a photo of him receiving that at their event. And in November, we were the winner in the AI category of the 2025 American Legal Technology Awards. This is actually not all the awards we won in 2025. I've left some off of this page, right? Because so much more happened. Like that was enough for 2025. But in December, we're still cranking out stuff. The justice initiatives get announced. So our inaugural Director of Justice Initiatives, Jessica Frank, wrote about the effort. Justice Initiatives will be a home for projects that push the boundaries of what's possible in justice tech and legal data, whether that means working with the courts to expand e-filing, advocating for more open and interoperable systems, or prototyping new solutions for persistent access to justice challenges. This division will be a place where we put ideas into action. This is super cool. Oh, look, we're not done with 2025? That's right. If you've ever used Hein Online, it's a giant repository of law journal articles, and now it's completely integrated with Court Listener. When you're reading all those journal articles on Hein Online, you can click and read the opinions too, connected to Court Listener. That's a huge integration. They have a giant set of stuff. Okay, so now we've made it to 2026. Here it is, February of 2026. And, among other things, Free Law Project is trying to provide free, public, and permanent access to primary legal materials on the internet. It's free because when it comes to making sure the mighty don't oppress the weak, when it comes to ensuring that the orphan and the widow are treated properly, one's financial situation should not be a factor. It's public so that everyone can access it. And it's permanent because we provide bulk downloads in our case law collection, and all our open source software that runs this operation is available online, so that no matter what happens to those of us working on it today, the next set of people that go to work on this effort can continue right where we leave off without ever having to start over again. Thank you.